For the third part of my presentation, I shall be discussing unjust dismissal. Unjust dismissal is the dismissal of an employee without any just or authorized causes and without the proper observance of due process. In the Philippines, under our legal framework, the termination of employment is dependent upon the right of the employee to security of tenure. Security of tenure is defined under our laws as the right of any regular employee to not be terminated from the services of his employment except for just or authorized causes. Just and authorized causes, which I shall discuss later, are the only grounds upon which an employee can be legally dismissed. Any ground or cause outside the ambit of that allowed by law shall entitle the employee to reinstatement without loss of seniority rights, his privileges, and his full-back wages. This is inclusive of the bonuses and other emoluments, other benefits and allowances that the employee would have received had he not been unjustly dismissed. This is computed from the time of his actual from the time of his dismissal up to the time of his actual reinstatement. For the purposes of this discussion, in the Philippines, an employer may terminate an employment only if there is a legal, just, or authorized cause. The ones that we usually see in movies or in television, where an employer can outright dismiss an employee, like in the series, if you're familiar with the series The Apprentice, where the phrase "you're fired" has become very popular. That is not allowed in the Philippines. In other jurisdictions, we refer to such right as at-will employment, where at any time an employee may be dismissed by the employer, whether or not there are grounds to do so. On the other hand, the employee may terminate his employment simply by serving a written notice to the employer, giving the employer at least 30 days or 1 month advance notice, and that will be sufficient for the employee to terminate his relationship with the employer. However, absent this due notice, the employee becomes liable for damages. But there are instances where an employee can also terminate his employment without any notice at all. Example of this, if there is such an agreement, or when there is a meeting of minds between the employer or the employee, where the employer allows the immediate termination for whatever reason the employee may give, or in instances where there is a breach of regulation by the employer against the employee, where or the instances where the employer commits a crime against the employee, such termination by the employee requires no 30-day notice and may be terminated. The relationship may be terminated at once. Just causes under the labor code are enumerated as serious misconduct or willful disobedience, gross and habitual neglect, fraud or willful breach, or just cause because of a commission of a crime. Serious misconduct or willful disobedience is when the employee intentionally disregards the lawful orders of his employer or the agent of the employer. However, these orders must be in connection with his work. The disobedience must be intentional, and the resulting damages to the property or the rights of the employer is serious, or the act itself should be serious. Jurisprudence distinguishes between serious and simple misconduct. Simple misconduct results in little to no damages, whereas serious misconduct results to substantial losses to the company or the employer. As to gross and habitual neglect, both qualifiers must be present, that the negligence committed by the employee must be habitual. It has happened before, it has been happening, it has happened again, and the possibility of being repeated is also there. Gross is that the nature of the negligence also results to substantial losses, damages to the employer. And all this negligence must be work-related or related to the obligations and responsibilities of the employee. Third, fraud or willful breach is the breach of trust of the employer repose upon the employee or his duly authorized representative. Fraud is the act of falsifying or creating false pretense in order to take advantage or in order to gain personally, and where the losses are also substantial, this may be invoked as a just cause for the termination of employment. Fourth is the commission of a crime. So basically, as the description would suggest, an employee may be dismissed or terminated from his employment because of the commission of a crime. The crime must be a breach of a law, not merely a rule in the company handbook, but a crime under the laws of the Philippines. So either under special laws or under the revised penal code. At any time when a crime is committed, either against the employer or any immediate member of his family, the termination of employment may be immediate. Also, the code provides for a catch-all provision which states that any other analogous cause may be just cause for termination. When we say analogous, any cause that may be similar or the same the same characteristics as to the foregoing, the first four mentioned. If it is similar, it can also be the basis for the just dismissal of an employee. As mentioned a while ago, there may also be authorized causes, and under the labor code, an employer may be terminated when such causes are prevailing. An example, among the 5 under the law, is the installation of labor-saving devices. These are the instances where the employer may introduce machineries and equipment that would reduce the need for manual labor or human input. In such a case, with the prior approval of the Department of Labor and Employment, an employer may terminate employees in order to save on cost. The second authorized cause under the law is when there is redundancy, when an employee is no longer needed for his responsibilities are a mere duplication of responsibilities already performed or capable of being performed by other employees in the company. In such a case, an employee may be terminated. Third is retrenchment. Retrenchment, in order to prevent losses, is when the company, in order to survive, is forced to reduce cost, and part of which is the payment of wages, by reasons perhaps due to loss in profits, a slowing down of business, and whatever reason, that retrenchment with prior approval of the Department of Labor would be viable in order for the company to survive. Fourth is the closing or cessation of operations, or when the business closes because due to perhaps a change in country or location, or in the cases of bankruptcy. When such event occurs, it is considered an authorized cause for employment to be terminated. And last, and perhaps the most common, is when disease causes an employee to be inefficient or no longer functional, or perhaps when the disease is contagious or prejudicial to the health of other employees. Such would be grounds for a proper termination of employment. That is the end of the third part. The next part will be discussed later.